because I need my home. I'm having another baby, and I'm stressed, and I'm trying to come up with as much money as I can, and they do not take partial payment. Hello?
I'm here.
Oh,
I'm sorry, they do not take partial payment.
no. So if I was to take the 25 down to the office, they would tell me I cannot put that on my account. I would have to come up with
I'm
the
sorry,
full amount.
Mr. Payne, you have
Yeah.
$2,500 right now to turn over to your landlord?
No, I'm trying to come up with that because that rule was said at me on the second to be concurrent. That's what we said. You told me last time when we was on the second to pay the 25 to get concurrent. And he just told me that it's almost 4,200. And I know at the office they don't take partial payments.
Mr. Graham Mason.
Yes, the last time we were here, they were looking to lift the stay, and they were stating the amount that was owed when the stay was entered. So that would have been 2462. It was 1960.09 was the amount of rent at that time. Since that time has passed, it's gone up now to 4,020.15 plus the court costs. I have the ledger in front of me. I don't have a representative to testify regarding that ledger, but looking at the amounts and how they've been processed, it is 4,020.15 that is currently due and owing.
Where we are right now, it appears, well, the court will lift the stay in this matter because we are at 118 days. Mr. Payne is disputing the amount of rent that is due and owing. Marianne, and how soon can we have this scheduled for hearing where Mr. Graham Mason could have his representative here to go over the ledger? Do you have our next landlord tenant date? I don't.
September 6th, you have a civil docket. I'm looking for, I don't know the next landlord tenant. Give me 1 second.
I'll just look in the afternoon on the 6th. Oh, that's next week. Wait a minute.
Yeah.
Yeah, everything's getting pushed over to Tuesday. It's not a fun time.
Are you already busy on Tuesday?
Everybody's mashing Monday and Tuesday together.
Mr. Graham Mason, as soon as it came out of my mouth, I knew the answer to the question. Let's look. We have Tuesday afternoon. Are you available?
Yes. Oh.
Yes. Everybody could be made available. Everybody could be made available. Yes, we can make everyone available if necessary, Your Honor.
Mr. Payne, are you available next Tuesday afternoon?
Yes.
Hold on one second. Marianne, I'm coming to get calendar. Hold on.
The gentleman who signed on as Galaxy A02, can you hear me?
Yes.
What is your name, please?
Anthony Terrell.
Thank you. Courtney, can you hear me?
Yes.
What case are you here for this morning?
The Barrington's apartment.
Is it under your name? Are you the defendant?
Yes, I am.
Mr. Katz, can you hear me?
I can hear you.
Hey, good morning. How are you?
Good. How are you?
I'm well, thank you. I don't see, I know the Barrington, I don't see, Courtney McIntyre on the docket.
McIntyre?
Yeah, do you have her?
Good question. Let me find out.
Okay, thanks.
Sorry, I'm in like trying to.
Yeah, that's okay. I can wait. Go ahead.
Courtney McIntyre, we sent in the dismissal. That was paid out.
Okay.
Oh, they didn't notify me. I didn't know. I called the office like a couple days ago and they said they still haven't received the check. So you guys received it?
They must have because I see that it's closed out on my end.
Okay, thank you so much. I'll contact the Barrington.
You're welcome.
Thank you, Mr. Katz.
So I can go.
Yes.
Thank you.
This Christian Payne, I need to ask a question.
You need to hold on till the judge gets back, okay?
Okay.
Mr. Katz, when you can, I just want to ask you a quick question.
You want to ask him a question?
Good morning, Mr. Byrne-Crant. How are you?
Good morning, how are you?
I'm well, thank you.
Mr. Payne and Mr. Graham Mason, next Tuesday, September 6th at 1 p.m.
Okay, I have one question.
Yes, sir.
How much do I need to pay to stay in my home?
Mr. Payne, Mr. Graham Mason has put that amount on the record. It's $4,020.15 is due and owing in rent right now. There's $164.53 in court costs. September's rent is coming due here on Thursday.
Right.
But because you're disputing the amount, the court is setting it for a short hearing date. We will be here next Tuesday, September the 6th at 1 p.m. Mr. Graham Mason will have his representative and the ledger. And we'll go over it. We'll take testimony at that time and the court will issue a ruling at the conclusion of that hearing. Anything else on behalf of the plaintiff?
No, Your Honor.
Anything else on behalf, Mr. Payne?
No, you've been very
Thank
helpful.
you,
Thank
sir.
you.
I'm sorry.
No, thank you.
We'll do this on Zoom next Tuesday. Have a good day, sir.
You too.
Bye-bye. This is 221582LT. This is Metro Commons versus Roark. Mr. Graham Mason, I note your appearance for the record. Mr. Roark, state your name for the record, please.
My name is Bleb Roark.
Thank you. Today is the day and time set for the adjourned hearing on plaintiff's request to lift the SARA stay. As in the previous cases, the SARA stay has been in place for 118 days.
Yes, we did receive an approval email on August 26th. And the approval is for the total amount of $4,920.95. In the email, it did state it would take 2 to 3 weeks in order for the payment to post. And the delays of the approval could be attributed to the lady from SARA needing additional information from the trailer park.
Does the email say that, sir? Your approval say that?
No,
Okay.
but we
Mr.
do
Graham
have
Mason?
Yes, at this point in time, the rent to retain possession, not including September rent, obviously, is 3896.75. Costs of
Wait, I'm sorry.
164.53.
I'm sorry. Three what?
Yes. $3,896.75.
Thank you.
164.53 in costs for a total of 4,061.28. And the representations made by Mr. Rourke appear to show that those would be taken care of in the event that a judgment were entered today at a point in the future.
I don't know who that is with noise in the background, but mute yourself if this is not your hearing. The stay will be lifted. Mr. Rourke, do you acknowledge and admit that $3,896.75 in rent is due owing?
Yes, I do.
Sir, in as much as you admit and acknowledge that that is the amount of rent that is due and owing, there remains no tribal issue of fact. Plaintiff is entitled to entry of judgment in that amount, that $3,896.75 in rent, $164.53 in costs, for a total of $4,061.28. You've indicated, sir, on the record that there's a SARA approval for $4,920.05. Based on that, Mr. Graham Mason, is your client willing to allow some additional time for receipt of those funds?
We would be willing to change the move out date in additional 7 days to accommodate that.
So that puts us on September 16th.
Yes.
Plaintiff's office will submit a judgment for that $4,061.28 with a writ date of September 16th, 2022. Mr. Rourke, what I would suggest to you is that you monitor whatever email you've been receiving from the SARA funder. Let them know that that is the date. Maybe that will expedite the release of funds to you. Anything else on behalf of plaintiff?
No, Your Honor.
Anything else on behalf of the tenants?
No, thank you. No.
Thank you, sir. Have a good day.
All right,
Thank you.
thank you very much.
Mr. Berncraft, good morning, sir.
Good morning, Your Honor.
How are you?
I'm doing just great. How are you doing, Your Honor?
I'm good. Do you have any of your cases ready, sir?
I don't see anyone here yet.
Give me,
I have 3 files.
you're scheduled at 9:30, so my cutoff time is 15 minutes after the scheduled start time. So if any of your, looks like what, 3 defendants appear, Marianne will get you into a breakout room with them, okay?
Wonderful, wonderful.
Otherwise, I'll start calling your cases at about 9:45.
Perfect. Thank you very much, Your Honor. I appreciate it.
Thank you. Good morning, Mr. Katz. Did I lose him?
Yeah, I don't see him
In the
anymore.
breakout. Thank you. Mr. Terrell, good morning, sir.
Good morning.
Have you had a chance to talk to the attorney from the Barrington?
Mr. Katz, no, I just received a letter for court today.
Sir, has your SARA funding been approved?
I went to the office and they said
No.
they hadn't received it yet. So I don't know what's really going on.
No,
I called
no. Mr. Terrell,
Yes,
has your SARA funding been approved?
not that I know of.
Okay, where did Mr. Katz go?
He just left.
Oh, he left.
Well, I don't see him anywhere.
I don't see him, and court's in session for me, and I'm prepared to call my 9:15 cases.
He was here earlier, though.
I know, I saw
Yeah,
him,
okay.
which is what has me concerned. But we have Clark, Reed, Baloo, and Terrell that I'm prepared to call here shortly. Clark, Reed. So we can stay on track with our time. Ms. Clark.
Yes, I'm here.
Has your SARA funding been approved?
No.
Do you have an update?
They haven't processed it yet. And when I called, they said they are still waiting to get to cases.
Danielle Reed. Danielle Reed.
I'm here.
Has your Sarah funding been approved yet?
Hello,
Hello?
can you hear me?
Yes, Ms. Reed, has your Sarah funding been approved?
The Sarah was denied, but I had a grab for more letter.
Okay, ma'am. No, ma'am. I'm sorry.
Yeah.
Don't answer the question. I'm not asking you. I'm just trying to figure out what we're doing. And Mr. Katz is back, so I'm gonna call these 4 cases scheduled at 9:15. This is 222347 LT. This is Barrington Romulus versus Clark. May I have your appearances, please?
Good morning, Your Honor. Sidney Katz, P 51471 on behalf of the plaintiff. Sorry, I've had some internet issues.
I know, I saw you disappear. Miss Clark, state your name for the record, please.
Hi, my name is Ariana Clark.
Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. That stay has been in place now for 83 days. What's the status of this matter, Mr. Katz?
So Your Honor, as of today, my client still shows a balance due of $6,805. So obviously, I don't think that they've received the Sarah funds at this point.
Is that just the rent part, sir?
That includes everything as of today, Your Honor.
What's rent and what's court cost?
Oh, I'm sorry. Let me break it down. So. It is 6,000. Hold on. I'm sorry. I'm having some computer issues. $6,640 of past due rent, $165 of costs for a total of $6,805.
Ms. Clark, do you agree and acknowledge that $6,640 in rent is due and owing?
I'm not sure, but yeah,
You're not sure, but yes.
yeah.
And ma'am, do you have a plan on how you're going to pay this amount of rent?
I can't pay the total amount right now.
Well, before Mr. Katz returned, the court did inquire regarding your Sarah status, and you indicated that it's still pending.
They haven't even looked at it. It's just been submitted. That's the status.
Ma'am, can you turn your video on, please? What do you mean it's just submitted? Help, please.
Give me a second to turn it on. I have to do through settings.
Ms. Clark,
Yes,
what do you mean it's just been submitted?
that's what when I go on, it just says submitted.
Okay. From the court's perspective, the stay has been in place for 83 days. The stay will be lifted. Mr. Katz has indicated that there's still rent due and owing of $6,640, court cost of $165 for a total of $6,805. The defendant has acknowledged that that is the amount of rent that is due and owing. And as much as the defendant has admitted and acknowledged the amount of rent that is due and owing, there remains no tribal issue of fact. Plaintiff is entitled to entry of judgment in the amount of $6,805.
Your Honor, just as an FYI, I have been in communication with someone from Sarah. I have inquired, they're going to try to escalate it. So hopefully the funds will come in before the writ's issued.
I'm sorry, it cut out when I did the video.
Thank you, ma'am. Directly in touch with someone regarding Ms. Clark?
Well, I've asked them about multiple outstanding Sarah applications. So, I mean, as indicated, it's been quite a while since we've had the stay put in place. So as it relates to that, you know,
So, Ms.
they will
Clark,
try to
what'll happen-
escalate it and hopefully she'll get the funds.
What will happen is that Mr. Katz will submit a judgment in the amount that was just placed on the record. Once you receive a copy of it with the court signature, you should ask for the matter to be escalated. Let them know that you have 10 days to pay, or plaintiff may make an application for an order of eviction, okay?
Okay.
Anything else on behalf of plaintiff?
No, Your Honor, should I put this down as hearing?
Yes, sir.
Thank you, Your Honor.
I have a
Anything else?
question.
Yes, ma'am.
Why is our stay only 83 days, but other people receive longer time?
Other people like whom?
Like the complex you did before ours?
What kind? Oh, ma'am, the stay is only supposed to be 30 days. There's an administrative order that says 30 days. This court does a 45-day stay. After 45 days, the plaintiff can come back and ask for the stay to be lifted. Some plaintiffs' attorneys just wait longer. Mr. Katz's office filed their request to lift the stay, and we just happen to be at 83 days. It has nothing to do with the length that the court allowed. If a plaintiff came back on day 46 and asked this court to lift the stay, I would schedule it.
Okay.
It's just, so it's nothing different.
Okay, I just didn't know. I just wanted to know, that's all.
No, that's fine. Anything else, Ms. Clark?
That is all.
Have a good day.
Thank you.
This is 222452 LT. This is Barrington versus Anthony Terrell. Mr. Katz, your appearance is noted for the record. Mr. Terrell, state your name, please.
Anthony Terrell.
Thank you. Mr. Terrell, as in the cases before, there's a Sarah stay that's been in place for 83 days. Before Mr. Katz returned, the court inquired and you indicated that you have not received any update to your Sarah application. Is that correct, sir?
Yes.
Mr. Katz, how much rent is due and owing?
Your Honor, give me 1 second. Currently, there's a balance due of $4,192 of past due rent, $165 of costs, for a total of $4,357.
Mr. Terrell, do you admit and acknowledge that $4,192 in rent is due and owing?
Yes.
Have you received any update from the Sarah, from the place you made your Sarah application?
Well, no, I haven't received. I called them. They told me that it was processing. They say they received it, and it's like my research too. So it's the second time I'm supposed to get it done. And they just told me it was processing. They haven't approved it or denied it.
Your Honor, as with the past one, I requested information. They indicated that it's going to be escalated. However, the balance that currently is owed is more than what he's going to be receiving, even when he gets, if he gets his Sarah funds on a recertification. So he's got to start making payments out of his own pocket, even if he's going to rely on that Sarah funding.
Mr. Terrell, are you in a
Yes.
position to begin making rental payments?
I just started working a little job like last week. I couldn't find employment. So I'll probably get my first little paycheck this week, but I had planned on, I know I have to pay out my pocket some. So I had planned on getting my money together until Sierra comes through, and hopefully everything will work out. If I could have something like probably a couple of weeks to make my first payment or something out of my pocket, I know because the rent's coming back up next week. So I know I'm not depending on Sierra to pay it off. So I have something to pay myself. But I just need a couple of weeks to get my money flowing and start saving and getting it together.
Your Honor, I leave that up to my client. At this point, as indicated, we've waited 83 days to get to this point, and there's a balance that's due.
Mr. Terrell, respectfully, where this court is we do not have the authority to force a landlord to wait more time. This
Right.
case was filed back on May the 24th, 2022. The stay has been in place now since June the 8th, 2022. Notice of today's hearing went out on August the 3rd, which gave you sufficient time to think about the funds that were available to pay towards the past due rent. this court's hands are tied in terms of extending that time. The court is lifting the stay. Plaintiff is entitled to entry of judgment inasmuch as you admit and acknowledge the rent that remains due and owing. Once the court signs the judgment, a copy will be mailed to you.
Okay,
You'll have the opportunity to be in touch with the people you made your SARA application to request that this matter be escalated. Mr. Katz has already indicated that he's been in some form of communication with that agency, but I would suggest that you do so as well.
yes.
Anything else on behalf of plaintiff? Mr. Katz?
I'm sorry, nothing. I didn't hear that.
Anything else, Mr. Terrell?
No, except for I was counting on the Sierra. I went into the office like a week ago and they told me about that they hadn't received it yet. And I didn't expect it to be that much. I was planning on paying my own, which is, I know is like $1,000 for my rent. But when I got through back, when I seen they haven't received it yet, so I'm like, man, I'm on top of what I got to do. Because last time I got Sierra, they just sent the email to the office and I didn't receive anything in the mail saying this is due or this is not due, hasn't been paid yet. So I figured that Sierra had sent the payment over. I didn't find out Sierra hadn't sent the payment over to like a week or so ago. That's all.
I understand, Mr. Terrell. But again, you'll get a copy of the judgment in the mail, and then you can follow up with the SARA people yourself and see if that'll help expedite payment in this matter. Mr. Katz has already indicated that even with the SARA payment, you will still have a balance that is due and owing, okay?
Yes.
Have a good day, sir.
Okay. Thank you, Judge.
You're welcome. This is 222348 LT. This is Barrington Romulus versus Danielle Reed.
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
I'm here.
Ms. Reed, state your name for the record, ma'am.
Danielle Reed.
While Mr. Katz was gone, the court inquired as to the status of your SARA application, and you indicated that you have been denied funding. Is that correct, ma'am?
Yes, the SARA was denied, the Wayne Metro was denied. I went through something called ERAP, and I've been having an issue with the card. I was awarded an amount. It wasn't the full amount, but
you were
I'm
awarded
working on
how
trying
much,
to
ma'am?
get that card. I believe it said $2,098, but they charged me $8 to get a new card sent out, and it still hasn't came yet.
Mr. Katz?
Your Honor, as of today, there's a balance due of $4,163 of past due rent, $165 of costs for a total of $4,328. At this point, requesting a judgment in that amount.
Ms. Reed, in as much as 83 days have passed since the SARA stay went into place, the court will lift that SARA stay. Mr. Katz has put on the record that there's $4,163 in rent due and owing. Is that an accurate figure, ma'am?
I believe so.
When did you make the request for a replacement card from ERAP?
On the 17th or 18th, I believe.
Did they give you any idea how long it would take to process?
They told me 3 to 5 business days, but they told me, I called yesterday. They said if I didn't receive it by yesterday, give them a call back again. So I was trying to wait because my power was out and everything. So I was gonna call back today.
Well, ma'am, again, the court is required to lift the SARA stay, and in as much as you admit and acknowledge the amount of rent that is due and owing, plaintiff is entitled to have the judgment entered as there is no tribal issue of fact. Mr. Katz's office will submit a judgment that shows $4,163 in rent, $165 in costs, for a total judgment of $4,328. He submits it, the court will sign it, you'll get a copy. I would suggest that you then make follow-up calls regarding the replacement ERAP card and make arrangements on how you're going to pay the balance that is the difference between the ERAP award and what your current rent is due and owing. Understood?
Yes, ma'am.
Anything else on behalf of the plaintiff?
No, Your Honor. Thank you.
Anything else, Mrs. Reed?
Do you know how much time I have to pay that? I'm sorry, it's a little out.
It's 10 days, ma'am.
10 days. Today.
Yes, ma'am.
Okay.
Have a good day.
Thank you. You too.
This is 222355 LT. This is Barrington Romulus versus Samantha Baloo.
Your Honor, I think I submitted a dismissal on this one.
I don't see it in the file, but I'm happy to sign the dismissal. If your office sent it, we're a little short-staffed on
Yep.
civil this week.
Okay, and I probably just sent it
I'll make a note.
yesterday, so I'm
Okay,
guessing it's sitting in someone's desk.
I'll make a note in the file that it's to be dismissed. Mr. Katz, you have some stuff at 9:30. But let's start with 222334 LT. This is Anmark Concord Club Apartments versus Deanna Cooper.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Andmark.
Have you been in contact with Ms. Cooper regarding this matter?
We had some brief communications in which she had requested a ledger. Took me a little while to get it to her. I didn't get it to her until this morning, but I also know I've been trying to call her and email her to appear today. I've not received a response. Was it, Your Honor, I'm not, since there's an attorney on the other side and there's been some communication, I'm not necessarily, I don't want to necessarily ask for a default today, but I would ask because I don't want to speak to Miss, they're both Miss Coopers, but the defendant, Miss Cooper, was it directly on this matter at this point, since she does have counsel? So if we could just do very brief adjournment, Your Honor, I'll give Miss Catherine Cooper, the attorney, another opportunity to be able to appear, and I can send her an email after today.
Are you available next Tuesday?
What time did you have in mind, Your Honor?
At 1:30.
I will make myself available, Your Honor. That sounds good.
Ms. Cooper, are you available?
My work schedule has not been determined as of yet, so I don't know. I usually work in the afternoons, but I can make an arrangement if that's the time. I can make myself available as well.
So let's say that for now. Actually, Mary Ann, we're landlord tenant on the 7th. The 6th was just a civil day. So I'm sorry, Ms. Cooper, give me one moment.
No problem.
I'll leave Mr. Graham Mason's case on the 6th, but let's do any adjournments from today on that 9/7, which is our regular second hearing day. I just want to look to see where we are.
I believe hearings are scheduled at 1 o'clock, Your Honor, because I think we're there already.
I just want to look because, oh no, Mary Ann, that looks bad. Holy smokes. You're here already on the 7th?
Yes, Your Honor, we're there on the 7th. It looks like it says at 1 o'clock in front of you. Was it on some matters that are coming back on Sierra stay lifts?
Oh, yeah. Oh, that looks bad. Holy smokes. That's not a good sign. Mary Ann, next Wednesday afternoon looks horrendous.
I don't even want to look.
There's 123 cases scheduled. That can't be right. That can't be a thing that we're doing here now. I guess it is. Let's try, next Tuesday, 9/7. I'm sorry about that. 9/7 at 2:30 p.m. And Ms. Cooper, if you could let the other Ms. Cooper know, we'll send out notice, but
And I'll send an email to Ms. Cooper as well, with the attorney, Ms. Cooper, on this matter.
thank you. I
Was it as well?
appreciate that.
So yeah, next Tuesday, the 7th, was it at 2:30 p.m.?
at 2:30 PM. Back here with Miss Cooper. You say you sent the ledger this morning.
Yeah.
I don't see anything else from your office this morning. I was thinking if Miss Cooper pops on late, but it is what it is. I'll see you next Tuesday at 2:30.
Understood, Your Honor. I was at, thank you. And then, yeah, we'll wish the court a good holiday too.
Thank you, sir. Thank you, Ms. Cooper. I will
Thank
see you
you.
next week.
Yes, Your Honor. Thank you.
Thank you. Mr. Bernkrat, this is 222459 LT. This is MIMG versus Taylor Ivy.
Yes.
Ma'am, have you had the chance to speak to the attorney for your complex?
No.
I was unaware Ms. Ivy was here, Your Honor.
Well, let's do the easy part first. Today is the day and time set for hearing on plaintiff's request to lift the SARA stay. That stay's been in place for 83 days. Miss Ivy, do you have an update from the SARA application?
Yeah, I checked it not so long ago. It said denied. Cause
You were denied?
yeah, it said I don't owe enough. Basically, it's supposed to be from March all the way up until now. Then if that mean I would have got approved. But yeah, I only
Mr.
owe
Byrne-
for like 1 month.
I'm sorry, you only owe how much, ma'am?
For like 1 month, like 5.
Mr. Bernkrat, how much rent is due and owing in this matter?
Yes, Your Honor, the amount owing as of today, including this month, is $655 plus the cost.
What's the cost, sir?
167. The total is 822.
Miss Ivy, do admit and acknowledge that that is the amount of rent that's due and owing $822. I'm sorry, the rent was $655 and then the court cost was 167 for a total of 822.
That's no, I didn't add the rent. I didn't add the court fees or whatever.
I'm sorry?
Yeah, now I know because I didn't add the court fees to it. But yes, I know now.
Okay. Inasmuch as you've acknowledged that the SARA application has been denied, the court will lift the stay in this matter. And you acknowledge that there's $655 in rent due and owing, plaintiff is entitled to entry of judgment inasmuch as there is no tribal issue with your acknowledgement of the rent. The plaintiff is also entitled to the court cost in this matter of $167. Mr. Bernkrat's office will submit a judgment in that amount, $822. Ma'am, you'll have 10 days to pay that amount or move from the property.
Okay.
Anything else on behalf of the plaintiff?
Not in this matter, Your Honor. Thank you.
Anything else, Ms. Ivy?
No, I applied for more assistance. I don't know why I keep getting denied for everything. That's it.
Ma'am, we're all set. You'll get a
Yeah.
copy of that judgment in the mail. Have a good day.
Okay.
This is 222460 LT. This is MIMG Gateway versus LaQuisha Perry. Today is the day and time set for hearing on plaintiff's request to lift the SARA stay. Notice was mailed to the plaintiff, to the defendant on August 5th, 2022, scheduling this matter for 8:30 a.m. It's now 9:53 a.m. Defendant has failed to appear. Sir, how do you wish to proceed?
With the lifting of the stay, Your Honor, and the entry of a default judgment.
Stay is lifted. Default judgment will enter in favor of plaintiff and against defendant. Rent to retain possession.
$4,135 plus court costs of $167 for a total of $4,302.
Based on the defendant's failure to appear this morning, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $4,135, court costs of $167 for a total judgment of $4,302. Plaintiff's office to submit the judgment with standard writ to issue date. This is 222466 LT. This is MIMG Gateway Townhouses versus Pamela Avery.
I'm here.
Ms. Avery, turn your video on, please. Mr. Berncrant, the court notes your appearance for the record. State your name for me in its entirety, ma'am.
Pamela Avery.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift Sarah stay in this matter that's been in place now for 83 days. Ms. Avery, what is the status of your Sarah application?
It still says submitted. I submitted it on May 24th. It hasn't moved. I spoke with someone yesterday. They just said that I'm still waiting to be assigned a caseworker. I have $2,500 of the past due balance. I'm not sure exactly what the past due balance is, but as of right now, I have $2,500.
Mr. Berncrant, what's the rent to retain possession?
Including this month, it's $4,510 plus the court costs of $167. The total would be $4,677.
Ms. Avery, do you admit and acknowledge that $4,510 in rent is due and owing?
Yes.
And ma'am, you've indicated that you have $2,500 to pay towards that right now?
Yes, ma'am. What is it called? Your caseworker is called state of emergency. I applied for that as well. They gave me 600, and I don't know exactly the amount.
You're breaking up a little bit.
Can you hear me now?
Yes, ma'am.
I applied, you know how you get a state assistance with like a bridge card and stuff like that. I also applied for, what is it called? A state emergency.
SCR.
I applied for the SCR. Yes, I applied for that. They gave me $600, but they needed some, not check stubs, but rent receipts. So I was told once I paid the $2,500, they'll release the funds to Gateway, and I have documents of saying that I was approved for the $600 and something.
Mr. Berncrant?
With the two payments that she has identified so far, it still comes up short of the entire amount that's owed. But perhaps with the assistance of a judgment, maybe that will push the parties faster, the funding sources a little bit faster.
Ms. Avery, at this time, the plaintiff is entitled to entry of judgment. That will be for the $4,510 in rent that you acknowledge is due and owing. They're also entitled to the $167 in court costs for a total of $4,677. Mr. Berncrant has indicated that you should pay that $2,500, and maybe entry of that judgment will help you speed up the process of getting the 600 SCR funds.
Okay. So you're saying that, are you saying that once the judgment gets sent out, like let Sarah know? Is that
I
what
would
you're saying?
send them a copy. I would send both Sarah and the SCR and state emergency relief people, let them know that there is a judgment. What this court typically does is after entry of judgment, if a plaintiff comes back and makes an application to have you physically removed with an order of eviction, I look at the fact that payments have been made, and I make plaintiffs explain that if somebody is making payments towards the balance and they've paid the judgment amount down significantly, this court is hesitant to enter an order of eviction. And I believe that most complexes would rather keep a tenant who's paying, at least trying to pay, versus have them removed from the property. So that means the $2,500, then the $600, then whatever other arrangements you need to make, or following up with the Sarah people so that they finish processing your application and get some payment out to your landlord. Okay.
Okay, thank you. Oh, quick question. Is there any way that, I know it take a couple of days for the mail to get sent to me. I know I can go online and look up the case search. Is there a way that I can just send them that so I don't have to wait? Because even if you put in the order today, I might not get the mail till when, like Thursday. So that cuts my time down. So is there any way that I can maybe?
You can go online. Yeah, yes, ma'am. You can go to the court's website and type in your case number. It's 34th District Court-mi.org, and you can type in your case number. And once they enter today's results, it'll say judgment enter or judgment to enter. And once Mr. Berncrant submits it, it'll say judgment enter. It'll be a little line on there. So do you know how roughly how long that takes? Because as soon as I get off the phone with you, I was going to give Sarah a call. It's not gonna happen instantaneously. I know that our civil staff is short this week. So today is Tuesday. It might not be until Thursday or Friday.
Okay. So when it
Okay.
enters from Thursday, so once it enters from Thursday to Friday, will it be 10 days from Thursday to Friday and not 10 days from today?
It'll be 10 days from the day the court signs it. So if Mr. Burnkrant's office emails it today, I'll sign it today. And it'll have the 10 days. It'll have
Okay.
that September 9th date. If he sends it the next day, we'll just, that 10 days adjust from the day that the court signs it. It's not an official order until it's signed.
Okay, thank you.
I hope I answered your question, ma'am.
Yes, you have.
Thank you, Ms. Avery. Have a good day.
You too.
Thank you. That's all I have for you, I think, Mr. Burnkrant.
That is correct, Your Honor. It is. Thank you very much. I'll draft those judgments right now and email them to the court.
Okay. Have a good afternoon.
Thank you, Your Honor. You do the same.
Thank you. This is 222342LT. This is Barrington Romulus versus Levi Streeter.
Good morning, Your Honor. Cindy Katz on behalf of the plaintiff.
Mr. Katz, today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay that has now been pending for 74 days. This matter was scheduled at 9:30 a.m. It's now 10 a.m. by the court's clock. Defendant has failed to appear. Notice of today's hearing was mailed to the defendant on August the 5th. Mr. Katz, how do you wish to proceed?
Your Honor, at this point, requesting a default judgment. This is a non-payment rent possession case. Currently, there's a balance due of $4,880 of past due rent, $165 of cost for a total of $5,045. Requesting a default judgment. Oh, you know what? I'm sorry. Let me take that back. I pulled the wrong line. Your Honor, there's $3,374 of past due rent, $165 of cost for a total of $3,539. Requesting a default judgment in that amount with the writ to be issued after December the 9th. For the court's reference,
December
Your
the
Honor.
9th?
I'm sorry, the what?
You said writ to issue after December 9th.
You know, I don't even know what year it is anymore. I think it's September the 9th, 2022.
Based on the defendant's failure to appear this morning, the Sarah stay that was previously in place has been lifted. Plaintiff is entitled to entry of judgment with rent to retain, default judgment with rent to retain $3,374, $165 in court costs for a total judgment of $3,539. Rent to issue on or after September 9, 2022. Plaintiff's office to submit that judgment to the civil department for entry. Anything else in this matter, sir?
Other than the fact that, Your Honor, they did receive some Sarah funds, and that's the balance after the Sarah funding has been received.
Wonderful. Thank you. This is 222345LT. This is Barrington Romulus versus Akeem Adams. Mr. Adams is here. State your name for the record, sir.
Akeem Adams.
Thank you, Mr. Adams. Mr. Katz, your appearance is noted for the record. Today is the date and time set for hearing on plaintiff's request to lift the Sarah stay. That stay has been in place now for 74 days. What's the status of your ERAP application, Mr. Adams?
They sent me approval for relocation.
Mr. Katz?
I'm not sure what that means. Relocation, does that mean he's going to be moving out?
Yes, they sent me the relocation assistance. Currently, I applied for a couple of different apartments. A lot of them have a waiting list. One of them I have a viewing for Thursday.
Mr. Katz, how much rent is due and owing?
Your Honor, as of today, there's a balance due of $4,880 of past due rent, $165 of costs for a total of $5,045.
Okay, Mr. Adams.
Yes.
So the relocation, you've been approved for relocation, which means they'll pay for you to move, but they won't pay for you to stay where you are?
Yes. I don't know why they didn't approve me to stay here. But when the approval came through, it said that I can read it off to you verbatim. It says Wayne County Rental Assistance, Relocation Assistance. Based on your application, the rental assistance program, you have qualified for relocation costs. And then it gives a breakdown of exactly how much they're willing to pay for the security deposit, the first 3 months of rent. That's what threw me off, because I was confused on why they didn't just approve me for them to pay and stay here, because I would rather stay here.
Mr. Adams, how much are you approved for?
It says, like I said, the security deposit, and then they'll cover up to 3 months of rent, depending on how much the rent is per bedroom. So if it's a 1 bedroom, $1,231, 2 bedroom, $1,573, 3 bedroom, $2,016.
So it's not a fixed amount.
No, it's just depending on.
So Mr. Adams, so when did you receive that email?
This was on the 22nd of July.
So 5 weeks ago.
Yes.
And did you respond to them and say, hey, by the way, I want to stay where I am?
Yes, and I still haven't heard anything back.
Mr. Katz, what do you want to do this morning?
Your Honor, at this time, I leave that up to Mr. Adams to see if he can figure it out with my client, but I'm requesting a judgment. I mean, we've waited plenty of time for this. He's had sufficient notice.
Mr. Adams, Mr. Katz has indicated on the record that there's $4,880 due in rent right now for your place at the Barrington. Do you admit and acknowledge that that is the amount of rent that is due and owing?
Yes, I do. I also would like to state that I just started working this week. I can start making payments towards the balance if the plaintiff is willing to work with me.
I leave that up to my client, Your Honor, at this time.
Okay.
Mr. Adams, you've been sitting through the docket, so you've heard this court say that because we are 74 days past entry of the Sarah stay, the court will lift the stay. And you admit and acknowledge the amount of rent that is due and owing of $4,880.
Yes.
Plaintiff is also entitled to the court cost of $165 for a total judgment of $5,045. Mr. Katz's office will submit it. The judgment, I will sign it. If you're able to make payments, as Mr. Katz indicated, you need to work that out with the Barrington. If you are making payments and you follow up with ERAP and ERAP wants to provide some assistance so you can continue living where you are, which makes more sense to this court than a new security deposit, that's something you work out with the management at the Barrington. If for some reason we get to the 10 days to pay or move and you haven't paid or moved and Mr. Katz, or you haven't moved, Mr. Katz makes application to have you physically removed from the property, the court does review the fact that you have made payments. So if you're in a position to pay down this money, this $5,000, you should start making payments towards that. Landlords are a lot more willing to work with somebody who's at least making efforts to pay versus waiting for ERAP to change their mind or some other funding source.
I totally understand.
Okay. I wanted to say it without saying it. Anything else in this matter, Mr. Katz?
No, Your Honor. Thank you.
Anything else, Mr. Adams?
No, thank you.
Good luck to you, sir. Have a good day.
Thank you, Your Honor. You too.
Thank you. This is 222349 LT. This is Barrington Romulus versus Tangela Fields.
Good morning, Your Honor. Cindy Katz on behalf of the plaintiff.
Good morning, Tangela Fields.
Good morning. Today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay that's now been in place for 74 days. The last time that the parties were here, we put that stay in place and Ms. Fields indicated, Ms. Fields, turn your video on for me, please. Ms. Fields indicated that there were some possible repair issues with the property. Ms. Fields, what is the status of your Sarah application?
They denied it. They sent me an email saying that they need some stuff. I sent her the email, the stuff that she needed. And then 2 days later, they denied it.
Did they say why they denied it?
Because my stuff I wasn't behind on rent until April. So because it was after April, I got denied. It wasn't from March 2020 to March 2022.
Mr. Katz, the rent to retain is?
Currently, there's a balance due of $5,114 of past due rent, $165 of costs for a total of $5,279, Your Honor.
And I did, sorry, go ahead.
No, you please.
I did apply. That was August 9th that I got denied, so I did apply for ERAP.
Ms. Fields, are you in a position to make payments towards this $5,279 that's due and owing?
Not right now, but if I can do it in payments, not the full amount.
Mr. Katz?
Your Honor, at this point, requesting a judgment, if she can work something out with my client, I'm okay with it, but I can't make any promises for that. But I think we've waited long enough.
But what about the damages I still have that haven't been worked on?
So, Your Honor, since we were in court, I have yet to hear anything from Ms. Fields as far as any specifications as far as what those items are. We've had 3 months for her to submit to me any itemized lists of any issues that exist. That has never happened.
You have never gave me any contact
No,
information.
Ms. Fields, no. Mr. Katz, finish, please.
So that's basically, I'm not aware of any of the specifics as to what issues exist. And I don't know what her communications with my client has been between the last time we were in court and now, as far as these issues. And at the
Ms.
same
Fields,
time, no
what-
money has
what are
been
the
posted in
repair
escrow with the
issues?
court as it relates
I'm sorry.
to any holdbacks.
Ms. Fields, what are the repair issues?
I have water damage. I had water damage in April where my apartment was flooding. I was in contact with maintenance, and they said that they were going to give me new carpet. They were going to switch me into a different apartment, and that the bathroom, because I also had flooding in my kitchen and my bathroom, that they were going to take out the whole sink and everything because it's dipping. It's going like this. And that was April. They have not done anything else as far as inside work.
And is this the reason why you're not paying rent?
Yes.
Well,
So you
obviously,
have
Your Honor,
the-
when you Your Honor, when you
Mr.
ask
Katz,
Ms.
no.
Fields if she is able to pay, sorry.
Will you let me do what I'm trying to do here?
Yeah,
So,
sorry,
Ms.
I'm
Fields, if
having
you're
an
not
internet
paying rent
issue.
because of these repair issues, you have the $5,114 in rent in escrow, correct?
In escrow, I do not have an escrow account.
You have the money set aside where you would have been paying rent if the complex had come and fixed these items.
If they would have came and fixed the items, yes. But
Okay,
it's not an escrow account.
so where is it?
I have it set aside. I'm taking it out of the bank and it's set aside, so it's in cash. But I've had to pay bills. Like I have other bills to pay, so I've had to dip into that. So that's why I applied for rental insurance or rental assistance.
Okay, so the easy part is the court has lifted the Sarah stay. I asked you a few minutes ago, and Mr. Katz interrupted me to remind me that I asked you, but I know that I asked, did you have the ability to pay towards the rent since you were denied the Sarah and the ERAP application is pending? And you tell me, no, you can't, even though I can clearly see that you're at work unless there's some other reason why you would be in a safety vest in a warehouse setting. And now you say that you have the money, that you weren't paying it in part because of the repair issues, but now you don't have all of the past due rent because you have other bills. So what's really going on? Do we need to have a full hearing in this matter? Or is there something else afoot?
I mean, we can, but like I said, I had other bills to pay, so I had to dip in it. That's why I said if I can pay it in payments and not the full amount. When you had asked me if I could pay it, I told you I cannot do the full amount, but I can do payments.
I can't pay the full $5,114, Your Honor, but I have $4,500, or I have $2,500, and I have another 1,000 in 10 days and another 1,000. That's what you say. I mean, I don't need to get into that because the issue is the amount of rent that Mr. Cass indicated is doing owing the accurate amount, $5,114. Is that what's doing owing in rent?
Yes, it is. And I am telling you that I had bills to pay. I don't know what type of money you think that I make, but I don't make that much. I
Oh,
make
no,
less
no,
than my
Miss
rent every week.
Ms. Fields, I'm interrupting you because there's no disrespect in my questions to you. And I've represented tenants for years, trust me. The issue is when somebody says, I'm not paying because of these issues, I expect to see the rent. And I know that somebody who is working for a living is not gonna sit and watch $5,000 accrue and know that they still have to do gas and I need an alternator and I need this and this and this. This rent money is going to get dipped into. But if the
That's what I
issue is,
said.
Your Honor and Mr. Katz, I'm having a financial hardship, will the Barrington work with me a little bit? It's a little bit different conversation than I'm not paying because they're not repairing.
But them not doing those repairs are causing health issues, which I have not been to the doctor, so there is no paperwork for that.
So how did you make the complex aware of the flooding and the sink and the carpet issues? Did you tell them? Did you email them?
Yep, email, because that was the only way I can get to them was email at one point, and then they stopped responding to emails. But I got pictures, I got videos saved up from even when I first got water damage, when I first started living there.
Your Honor, if I can ask when the last communication she had with my client is?
Beginning of August.
And who did you speak with?
It was the email. So
Okay,
it was.
have you stopped in
Nicole's-
their leasing office at all? I mean, you say that you keep
I
on
have.
emailing them, but you're having no success.
Because I'm sorry, my phone is dying. I also have another job. That's the only way I can try to maintain those. I just started my second job. So I have not stopped
Okay.
in lately now.
So Miss Fields, Mr. Katz, she seems to be asking for a set off based on these repair issues. And you don't have a client available for you right now for us to launch into this. And we have other cases from the 9:30 docket. Are you able to get them here next Wednesday for an actual hearing?
Possibly, Your Honor, but I guess if Miss Fields is having such issues with the apartment, I have no problem converting this to a termination case. And if she's, if she had indicated some health issues or whatever it might be, I don't mind if she, probably it's best for her to find another place.
I do mind when a landlord's response to someone asking them to fix the property is, why don't you just move? No, why don't you make the repairs?
No, I understand that, but
if you're able to check with your client and there are actual emails where she's asking for repairs, and we come back next Wednesday afternoon and Ms. Fields has a stack where she's emailing them at an email address that they've used to communicate with her, and they're not responding, unless she just wants to move, this court's response to somebody asking for repairs is not for them to move. It's for your client to maintain the premises. I love all their advertising regarding the updates that they're making to the property. And it does look nicer than it's looked recently. So there should be no problem in them making the repairs that she's requesting. So what we'll do is we'll come back next Tuesday at 3 o'clock. Holy smokes.
And Your Honor, if I can ask Ms. Fields if she could email me a copy of her most recent communication with them, just so I know what's actually the issue, so I can address them with my client.
What's your email address?
So it's SIDNEY, my first name, .KATZ, my last name. So Sydney.Katz@yahoo.com. Now, Your Honor, I have usually, when someone brings up issues, I usually do ask them to send me information as to what those issues are. I don't recall if we did that in the first hearing or not, but it wouldn't be the first time I've asked for it.
We did not, because I typically make notes that say, we told the defendant to send the list, and there's not a list in there. There's no note in there. It says possible repair issues. It doesn't say And I know that we didn't go into it because we put the Sarah stay in place.
Okay.
So Ms. Fields, Mr. Katz has now provided you his email address. Email him what it is that he's requesting, because what this court typically does is if you have pictures, documents, and et cetera, to show that you've been asking repeatedly for the same thing, your landlord hasn't been complying or responding, and it has deprived you of the full use of your apartment, that's a rental abatement, and the court will be looking to reduce your the amount of rent that has been due since you've been asking without response. But if it's small things like the crisper tray is broken or a missing 3 mini blind slats, the court does not find that, would not find that to be significantly impacting your use of the property. If you're showing me that the sink is unusable and one of the toilets doesn't work and I can't lock the door if I don't put a chair under it, those are significant things. So between now and the time we come back next week, we'll be on Zoom next Wednesday at 3 p.m. Send Mr. Katz to his email address the emails and the specific list of damages. The court has the ability for you to submit those same things to the court electronically, or bring a copy. Whatever you give Mr. Katz, have an identical copy to the court. Because when we have our hearing, it'll be by screen share, which means you'll submit, you'll have access to the Zoom to show the court the same emails. I like to have the stuff beforehand though, so we can look over it and be looking at the same thing at the same time. If it's just a financial issue, Ms. Fields, we can take it up again next week, and it'll give you some time to go over what your resources are on hand. And you can say to Mr. Katz, listen, we're not going to have this full hearing. I have X that I can pay right now, and I can pay X in another week or 10 days, and we'll resolve the case that way, maybe in a way that's more advantageous than a full hearing. Are we on the same page, Mr. Katz?
Yes, Your Honor. What I
Anything
think
else,
maybe
Ms.
Ms. Fields can do in the meantime
Is this-
is actually try to call my client or stop by their leasing office. Obviously, if the emails don't work, I would like this matter to be resolved before we're back in court next week anyway. Not just for Ms. Fields, but it doesn't help my client because their asset, if in fact there's water or issues, it's not going to help them in the long run. So I'd like to see if this matter can be addressed before we're back in court.
It will. Will this be the same Zoom number or no?
Same Zoom number, ma'am.
Okay, thank you.
Thank you. I'll see you next week.
Yes.
Thank you, Your Honor.
Thank you. Mary Ann, don't let me put anything else on next Wednesday afternoon.
Okay.
It sounds good to say it out loud, but I don't know that I can remember. 222353LT. This is Barrington Romulus versus William Byers.
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
He was here.
Your Honor, before we go into that, did you say it was a Tuesday or Wednesday? I thought you said next Tuesday was the Fields case.
No, the 7th, 9/7.
That's Tuesday. Oh, that's Wednesday. Oh,
That's
okay.
Wednesday.
Okay. Just making sure.
Mr. William Byers was here. I saw him. He left and came back, and now he's gone. Mr. Katz, the court notes your appearance for the record. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that's been in place now for 74 days. The defendant called the court to confirm today's date on August the 10th. What's the status of this matter, Mr. Katz?
So, Your Honor, I did communicate with Sarah. There still has not been a payment made on his Sarah application. They did indicate that they will try to escalate the matter. However, in the meantime, as indicated, there has been sufficient time. And there's currently a balance due of $4,640 of past due rent, $165 of costs, for a total of $4,805.
Thank you, Mr. Katz. Because Mr. Byers did appear, the court's making a note in the file that he was here, did not stay. The case has been called now at 10:23 a.m. The defendant is showing as having failed to appear in as much as he did not stay for the case to be called. The court will lift the stay and enter default judgment in the amount of $4,640 for rent to retain, $165 in costs for a total of $4,805. plaintiff's office to submit that default judgment.
Thank
Anything
you, Your
else
Honor.
in this matter, Mr. Katz?
No.
This is 222351 LT. This is Barrington Romulus versus Gerald Flint. Gerald Flint. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay has been in place now for 74 days. Notice to appear this morning was mailed to the defendant on August the 5th, 2022. Court's called the matter twice now. Mr. Flint has failed to respond. Matter was scheduled at 9:30. It's now 10:24 by the court's clock. Defendant having failed to appear. How do you wish to proceed, sir?
Your Honor, at this point, requesting a default judgment. It's actually Miss Flint, I believe. Currently, there's a balance due of $2,821 of past due rent, $165 of cost for a total of $2,986. Requesting a default judgment in that amount with the writ to be issued after September the 9th.
Gerald Flint, you have as a Miss Flint?
I think it's a Geraldine, but you know what? I might not be 100% right.
Don't say that because your notice to vacate, your demand for possession, I'm sorry, says Gerald. The summons and complaint says Gerald.
Right, I think that's how she goes by. I believe it's a
Goes by
Geraldine, but
Gerald.
I might be wrong.
We're stuck in the minutia of it because it doesn't matter when the defendant, no one from 10111 Diane Drive, 23-301 Romulus has appeared in this matter. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $2,821, $165 in court costs for a total of $2,986. Plaintiff's office to submit writ date of September 9th. Anything else in this matter, Mr. Katz?
No, Your Honor.
This is 222484 LT. This is Pinewood Circle versus Tanisha Chandler. Tanisha Chandler. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that's been in place for 76 days. Notice to appear this morning was mailed to the defendant on August 5th, 2022. Tanisha Chandler or anyone from 34215 Pinewood Circle, number 07206. Matter having been scheduled at 9:30. Defendant having failed to appear at 10:26 a.m. Mr. Katz, how do you wish to proceed?
Your Honor,
Ma'am.
at this time- oh,
I am so sorry. You said 34215 Pinewoods.
yeah, but this is a different
Yes.
case, Ms. Coleman.
Okay,
You're-
okay, sorry. Okay.
Mr. Katz,
Yes, Your Honor, at this time requesting a default judgment. Currently, there's a balance due of $3,513 of past due rent, $165 of plus for a total
Nope,
of $3,000.
Mr. Katz. you broke up for a second.
Oh,
$2,513 and then what for cost, sir?
no, it's 3,607, 3513, 3513,
3513.
of past due rent, 165 of costs, for a total of $3,678. Requesting a default judgment in that amount with the writ to be issued after September the 9th, or, yep, 9th.
Gerald Flint has been trying to connect. He's going to give it another try now. He's been in contact with the civil department. I'm pulling the file back for a half a second, see if he can get connected. But for the Tanisha Chandler matter, defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $3,513, $165 in court costs for a total judgment, $3,678. Plaintiff's office to submit that judgment. This is 222638 LT. This is Pinewood Circle versus Tiara Coleman.
Hi. Good morning.
Turn your video on, state your full name for the record, please.
Tiara Coleman.
Thank you, Ms. Coleman. Today is the day and time set for, oh, no, where's your attorney?
I know that's what I don't know that he said that he would be in the courtroom with me and I didn't see his name.
Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. That stay's been in place for 76 days. This court received an appearance from a David Borowski on August the 17th, 2022. Mr. Katz, have you received that appearance as well, sir?
You know what? I believe I might have, which is odd because Mr. Morowski is usually, and let me just see my last communication with Mr. Morowski as it relates to this case.
While you're looking for that, Mary Ann,
Yes.
trying to connect means
He's
he
been
was
trying,
late?
yeah, he may have had the wrong, Zoom ID. Jackie was not sure, but but she was in contact.
Miss Patterson,
Yes,
what are you here for, ma'am?
I have a case with you today. I was scheduled for 10:15 for malicious destruction of property.
No, ma'am, not with me.
On my, it says Lisa Martin,
What's your first name?
Rainisha.
Ranisha?
Raenisha.
That's tomorrow, Miss Patterson.
Oh,
My docket
okay.
today is just landlord tenant. Give me 1 second. I reviewed your file last night. Your hearing is in fact
Because the
tomorrow at
charges was supposed to
10:15.
be dropped.
Ma'am,
Yes.
today is the 30th. The case is scheduled for tomorrow. Wednesday is my criminal day. I will see you tomorrow.
Okay, see you then. Thank you.
You're welcome. Are you still reading your email from Mr. Murkowski?
No, I had sent him a copy of a ledger. I think he had indicated that there were Sarah funds, but those funds have already been received. And I think my last communication to him was that the amount owed, the arrearage far exceeded what was going to be coming from Sarah.
You understand that I'm not listening beyond he's not here this morning, so I don't know what you want to do.
Yeah, I guess I
Client's here,
figured that.
He's not, and we're late. I mean, he's late, which is unusual for him.
Do you want me to try to reach him?
You want to do that? That'd be great. Ms. Coleman? Are you okay to hang around for a little bit to see if Mr. Cass can get a hold of your client? I would say your attorney? Absolutely. Okay. I'm gonna go, I'm gonna step off for 1 minute, Mr. Katz, if you can get a hold of the defendant, I'm
Yeah.
sorry. If you can get
In
a
the
hold of
meantime,
him,
can
and
I
we'll see if
shut my-
Mr. Flint pops back.
Yeah, can I just shut my Zoom down because I'm having some communication issues and maybe
That's
it'll
fine.
reset?
That's fine.
Okay, thank you.
Thank you.
The person who just joined, identified as iPhone, can you hear me? Oh, no.
Oh,
Oh, what?
I put an iPhone out because they had noise in the background and they weren't connecting.
There
They
were a
weren't turning
lot
their
of,
video on.
yeah, there were a lot of iPhones this morning, though.
Hello?
Mr. Flint,
Yes, ma'am. This is he.
you were in earlier and the court put you out.
They did?
Were you connected? Were you connected earlier and you were removed from the hearing?
I'm almost for certain I was. I thought I was,
Yeah,
but
I put you out because you came in and there was noise in your background and I was trying to get you to be quiet.
oh, I apologize. I'm sorry. I was at
No,
work.
no, you, Mr. Flint, don't apologize. That was me. And I was hoping you would come right. I didn't put you out. I put you in the waiting room and I was hoping you would come right back. And now the attorney is here. He's aware. Are you driving?
Yes, ma'am. I just got off the phone with one of your court people. When I was going through stuff, I told her I'd just come up there. I said,
No. Mr. Flint, stop driving when you get, or how close to the court?
I am not close at all, ma'am. I work in Dundee, Michigan, so I am extremely far. But
Mr. Flint,
yes,
I have a case with 2 attorneys that I'm going to call, but when you get somewhere and park, I'm gonna recall your case. You're fine.
okay, I will do. Will do. I'll get off in the next 2 exits.
Okay.
Thank you.
Thank you.
I'll stay in it. So stay in this, right?
Yep, you can stay in
Okay.
there. You can stay
All
in
right.
here. Just be quiet.
Okay.
This is 222638 LT. This is Pinewood Circle versus Coleman. May I have your appearances, please?
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
Good morning, Your Honor. David Morosky on behalf of the defendant. Your Honor, I apologize for my tardiness. I had this miscalendared and I appreciate Mr. Katz contacting me.
Thank you. And Ms. Coleman is here. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. The stay's been in place now for 76 days. Mr. Morosky, what's the status of this matter?
Your Honor, I'd have to check with Mr. Katz. I know there was a recertification request that had been sent in. I'm not sure if that was received and whether it was enough to bring her current. If I could have a moment to speak to Mr. Katz in that regard, I would greatly appreciate, Your Honor.
Absolutely.
Good morning.
If we could be put in a break, thank you.
You're going into room number 1, sir.
Thank you.
Sounds like the temperature just dropped, Mary.
Because some people were just walking in the hall.
Some people,
Yeah.
You are shady. And that's all I'm gonna say about that. I love that I recognize that name from tomorrow's docket.
Which, oh yeah, exactly. That helped. That was helpful.
I didn't recognize the first name, but then when she said, I didn't recognize her last name, but when she said her first name, I was like, oh yeah. I read that file last night.
Okay, so I looked up our calendar for next Wednesday. What? I shouldn't have.
What would happen is we received Sarah stay lists, and I don't want them to wait. We have 2 weeks of landlord tenant now because we're done with our we're 2 weeks of criminal, then 2 weeks of second hearings. Uh-oh. And I don't know what the 14th looks like, but I know that there was a week of second hearings that they did not do. So I knew that our 2 weeks were going to be heavier.
Oh, okay.
And I don't remember the why they skipped a week, but I knew the 7th was going to be bad, and I didn't necessarily want the 14th to be just as bad. Let's look and see what the 14th looks like. Oh, yeah, the 14th looks a lot better. Well, there's 23. It says 23, but it's actually not 23. It'll be 11. Because they count each entry as a singular hearing, but there's 2 sides to every hearing. So next week, 123 is actually only 60.
Well, that sounds a lot better.
It does. I thought of, as soon as I said, I was like, wait a minute, that's not how it goes. Because the criminal cases are just one line, because they don't list the jurisdictional, the law enforcement name. And there are not that many carrying over from this week, are they? 1, 2, 3. That's not bad. Ms. Cooper probably will follow up and get that resolved with Mr. Morton's office. And then Christian Payne, that's just money, not just money, you know what I mean? The only hearing will probably be Fields. And because they're short down there, I don't know if there's anything that you can do to be of assistance.
Yeah, I can find out, like, if they need notices or whatever.
Was that sufficient time in the breakout room?
Yes.
Yes, Your Honor.
How are we proceeding, Mr. Morosky?
Your Honor, Ms. Coleman recently received another invitation to recertify under Sarah. I'm going to reach out to Wayne Metro to get that recertification expedited. So we would like a 2-week adjournment to see if that can be paid out, because she's already been approved a few times before. Now, it's my understanding she may owe some balance on her own, which I will speak to her about. But because September's rent is becoming due at the end of this week. We just like a 2-week adjournment, Your Honor, to see if we can get this last recertification expedited.
Mr. Katz, any objection to the adjournment?
I'm good with it.
We'll put this over to September the 14th, 2022 at 10 a.m. back on Zoom. 9/14, 10 a.m. back number 1 on Zoom. Anything else, Mr. Katz?
Not at this time, Your Honor.
Anything else, Mr. Morosky?
No, if I could just speak to Ms. Coleman briefly in a breakout room before we leave, that would be great.
Mary Ann will put you back into number 1. Thank you.
Oh, okay, I'm going to 2, but
Oh, 2, dealer's
Okay.
choice.
okay, thanks.
Ms. Coleman, please join your attorney. Mr. Katz, Mr. Flynn is here. I was waiting for him to pull off because he was headed this way when he couldn't connect. Mr. Flint had been here previously. He was on
Yes.
this is 222354LT. He was on an iPhone unidentified. When I tried to get him to communicate with the court, he did not respond. So I put him into a waiting room. He disconnected and now he's back. Mr. Flint, the court called the case previously at 1024. What is the status of your Sarah application, sir?
Can you guys hear me?
Yes, sir.
Okay, my Sarah status, I spoke with them Monday. I spoke with them yesterday to see if I can get it expedited because that's what my apartment complex asked me to do. And they said, until it's in the red, until they gave you a judgment of eviction, we cannot expedite it. I said,
And we'll
okay.
We'll do that, Mr. Flint. Mr. Katz was on previously, indicated that you owe rent of $2,821. Is that correct, sir?
I'm almost for certain that is correct. I honestly thought that this would have gotten taken care, or they would have helped me a little earlier than this. They did explain to me yesterday that they are very far behind. They are nowhere near where they want to be with helping people. I told them, okay, well, now it's time for me to just start paying on some things myself. I'm gonna try to get that down myself before they even help, because they are extremely behind and I don't want to get evicted while I'm waiting around on them.
So, Your Honor, I don't know if this is a Sarah application. I think this is more of a SDR application for two reasons. One, he indicated that they're looking for some paperwork, maybe a judgment or something like that. But also, when I reached out to Sarah, they indicated that there is no current application. They said that they could send a ping for a recertification, but that was not done as of last week.
Well, actually, when I just spoke with them Monday, they told me that I got my last Sarah app in by June 30th, which was their cutoff date, and I have my recert number right here. I got my Sarah app number right here.
Okay, what is that number? Because
Oh, I know exactly what happened, ma'am. When I called them Monday, they expected me to give them a recert of my same number. They said, why isn't your recert the same number? I said, I don't know. When I recertified, they gave me a different number. The first time it was a 162 number. This second time around, it was a completely different number. He said, this is the first. I don't know why they did that, but you don't have the same. It should have been the same number with recert, same number with recert 2, same number with recert 3, but my number has changed. But you ready for it?
Yes.
Go ahead.
It is 753-863. 753-863.
So that's a brand new application. That's not even a recert number.
That's what I'm saying. I don't get what I did wrong, but he said it still was in, but it was not a recert, which I went to the same exact Sarah.org. I went to the same exact website, recert. They still have my info. They still have my son's info in there. They still have my address. That's why I was very confused when I ended up with a new number. I'm thinking, hey, did I use it? Am I exhausted? Do I not get it? The guy said, no, you got it in before June 30th. I'm just really confused why this is a different number. I said, I don't have the slightest clue, man. But I know when I spoke with them on Monday, the 162 is no longer working. They gave me a brand new number. Yeah.
All right. So, Your Honor, under the circumstance, I mean, we have had a 73-day stay on this. I still would request at this point a judgment giving Mr. Flint until the 9th of September to resolve this matter. If he does have the wherewithal to pay it out of his own pocket, that would solve the issue of waiting for Sarah funding.
Mr. Flint, the court will lift the Sarah stay and enter a judgment that shows that amount of rent at $2,821. There's $165 in court costs that the plaintiff is entitled to, for a total judgment of $2,986. Mr. Katz will submit it. The court will sign it. You'll get a copy. If they told you, they being Sarah told you that a copy of the judgment would expedite things, or
That's what they
elevate
told
the
me.
review of your, or escalate a review of your file, take them a copy of the judgment. If for some reason we get to that September 9th date and you haven't paid or moved, and Mr. Katz makes application for an order to evict you, the court does review the file to see if you've made payments. So if you're in a position to make some payments, you should make some payments. That won't stop the Sarah from being processed, but we want to be sure that you're in the best possible position to protect your housing, if that makes sense to you, sir.
Yes, ma'am. Thank you
Okay.
so much. Yes, that is.
So that's what we'll do. Mr. Katz will email the judgment over. The court will get it signed and get a copy out in the mail to you. Anything else in this matter, Mr. Katz?
No, Your Honor. Thank you.
Anything else, Mr. Flint?
Yes. Is there a way that I can just copy from you guys so I can go ahead and, or does it have to be through the mail? I don't know how it works.
It does have to be through the mail because Mr. Katz emails it to the court for signature. Once I sign it, it goes back downstairs and they mail it out. And they're not, I know that the staff downstairs, they're short this week, so it's not like they can call and say, come get a copy.
Okay. I just don't
I'm sorry about that.
No, it's fine. I'm really trying to get on Sarah about this. I don't want anything bad or negative to happen to me while I'm waiting on their, that's what they told me. Hey, it'll get expedited if you were like outright getting evicted, which is already scary enough to tell me, hey, we can't really help you until you're 1 foot out the door. But if that's what I have to do, that's what I'll do.
Thanks, Mr. Flint. Listen, drive careful, get off the phone.
Okay, you have a good
Have a
one.
good afternoon, sir.
All right.
Mr. Katz, that's it for me. The
Yeah,
next
so
two
can we go
cases are
back to one
miscellaneous.
of my files because I made an error, surprisingly.
What?
It is the file of Pinewood versus Tanisha Chandler. And by the way, I was wrong about
Mary Ann,
Mr.
I need
Flint,
you to
obviously.
Mary Ann, mark this place in the Zoom recording that Mr. Katz has said that he made an error. I don't know that I've ever heard those words
No,
come out
I
of
said
his
it
mouth.
twice today. I was wrong about Mr. Flint. I was wrong about this balance. I'm on a roll.
The planets are aligning in such a, this is 222484LT. This is Pinewood Circle versus Tanisha Chandler. Mr. Katz, you wanted to modify?
Yes, Your Honor, I inadvertently included September rent in the judgment amount, so I do need, and this is the only one that I did that with, just for
Lies, he
reference.
tells lies. Mary Ann.
Your Honor,
What's the
as of
correct
today, there's a
amount?
balance due of $1,975 of past due rent, $165 of costs, for a total of $2,140.
Mr. Katz, the court appreciates your honesty in correcting that oversight. I've written the updated correct amount in the file. And just so that we're clear on the record, $1,975 rent to retain, $165 in cost, for a total judgment of $2,140. Plaintiff's office will submit a judgment in that amount to the court for entry.
Thank you, Your Honor.
Anything else?
That's
Good to
it.
see you, sir.
Thank you. Have a good day. See
Take
ya.
care. Wait. That was the Grand Mason one, Mary Ann, that has I put on the 6th. I'm going to leave it on the 6th.
Okay.
So, okay. Ms. Coleman?
Yes,
As much as I enjoy your company, I think we're done with your hearing, ma'am.
thank you, ma'am. Have a good day.
You too, thank you.
You're welcome.
Judge, are you out there?
I sure am.
Hey, I just got a phone call. I'm coming in there.
Da, 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 da. This is 22068 LT. This is Parkwood Manor versus Sartara White. It appears on this court's docket today at 11 o'clock for hearing on an eviction. There is no application for an eviction in the file. There's no fee having been showing on the register of actions as having been paid with the application for eviction. And as much as no one's appeared at 11:15 for an 11 o'clock hearing, there being no application to file, no application fee having been filed, applications denied. We're 82 days past judgment. Same thing in 2200870 LT. This is Parkwood Manor versus Charisma Harris. The matter was scheduled today at 11 o'clock for hearing on plaintiff's request for entry of an order of eviction. And as much as no parties have appeared, applications denied. That concludes this court's docket for the morning. Mary Ann, I'll take us down. Thank you.